Good day. Welcome to another episode on the Law Report. Today, I want to talk to you about the doctrine of parliamentary supremacy or sovereignty. Now, to be clear, this is not legal advice, and for legal advice, please contact a competent attorney. The doctrine was first pronounced or introduced by Professor Dicey way back in 1885. And according to Dicey, Parliament is always sovereign and cannot limit its powers. That was the first principle, according to A.V. Dicey. So, in other words, A.V. Dicey posited that Parliament was the supreme authority to make laws and to unmake laws. The second principle is that the courts cannot overrule parliamentary legislation. And the third principle is that no parliament can pass laws that future parliament cannot change. So in other words, one parliament cannot bind the other. Now, there are scholars who have argued that even with devolution of powers, where the UK Parliament actually grant powers to bodies like the Scottish Parliament, the Welsh Assembly, or the Northern Ireland Assembly, or even the UK entry into the European Union, which at the time was the Economic Union, and a subsequent withdrawal in 2020, or the introduction of the Human Rights Act, or the decision of Parliament to establish the Supreme Court in 2009, which effectively ended the House of Lords as the United Kingdom's court of final appeal. Despite these developments, constitutional legal scholars argue that in theory, Parliament can repeal any law that brought these changes into effect. And they advance that the very ability, the very power of Parliament to undo any act that was done is essential to parliamentary supremacy. So if Parliament had made laws that it could not have repealed, then the doctrine of parliamentary supremacy would have been in jeopardy. But the power of Parliament to undo what it did lends support to parliamentary supremacy. Further, the court cannot invalidate an act of Parliament. The court may only rule that an act of Parliament is incompatible with the Human Rights Act. And any ruling of incompatibility allows Parliament to just amend the legislation to bring it into compliance. And there's also mechanisms where the court can actually read down certain legislation to bring it into compliance with the Human Rights Act. There are two cases that I believe are very important to the whole notion, the doctrine of parliamentary supremacy. The first case is that of our Secretary of State for Transportation, ex parte Factor Thing. In this case, legislation was passed in the UK requiring ships registered in the United Kingdom to have a majority British ownership. Subsequent to the passing of this legislation, a group of Spanish fishermen brought an action for judicial review of this piece of legislation, alleging that it breached European Community law. It was held in this case that European Community law did supersede British law, or did supersede legislation passed in Parliament. However, in the case of Jackson, the House of Lords, albeit omitted, suggested that there may be limits on parliamentary sovereignty, but in the United Kingdom, it was unlimited. Notwithstanding the fact that the case, constitutional scholars have opined that the bedrock of the British Constitution is the supremacy of the Crown in Parliament. So in conclusion, notwithstanding the devolution of powers, criticisms of the doctrine from constitutional scholars such as Sir Ivor Jennings and others, notwithstanding the membership of the European Union, which ended in 2020, the introduction of the Human Rights Act in 1998, legal academics have argued that the doctrine has just merely been wounded, but has remained intact. It appears that despite the legal, social, and political changes which occurred since 1885, every diocese doctrine of parliamentary supremacy is here to stay. It's not going anywhere. We just have to live with it.